What happens then? If we are not married by common law, which, gives us some rights and responsibilities, we should still have those same rights and responsibilities, right? Uh, Hey, everybody, it's Lisa Knox here again with Knox Law Mediation, reaching out to you all from the great state of Florida in sunshiny Tampa Bay. And as y'all recall, we deal with all things family law here. So today we have a very interesting topic. We're still on our subject of MythBusters, those old wives' tales and myths that have been passed down from generation to generation. And it might be wrong, it might be right, but we're still going by it for some reason because great-great-grandmother's cousins, uncles said we should. I don't know. Anywho, so we have a great one today. Okay, are you all ready for this? We've lived together for I don't know how many years, and we've never gone down the aisle, but we don't need that piece of paper. We're still common law married, right? This is interesting. How many of us know someone, and it's typically older people who are like, oh, they've been in a relationship for 15, 20 years and all. Grandma's special friend, Mr. Charlie, and so forth, Mr. Robert Edward, and so forth. And come to find out, they've never gotten married. They've never gotten married. They've bought property together. They've gone on trips together. They've raised a family together. Everybody knows them as husband and wife. They've always known them as husband and wife. They celebrate anniversaries together. They support each other's careers. They start a business together. All of those things must mean that they, even if they didn't get legally married, they must be common law married, right? Like everybody knows them as married. So that would be common law married. Except in the state of Florida, there's no such thing anymore as common law marriage. State of Florida does not recognize common law marriage. Now, it will recognize common law marriage that has already been considered and deemed a common law marriage from another state. However, there's not a lot of states that recognize common law marriage. Now, what does that mean? That means that if you have been in a relationship with your significant other for the past 20 years, and you all have children together, and you all share family, and your family loves each other, and you built homes together and started businesses together, then guess what you two are? Legally, you're just friends. Legally, you're boyfriend, girlfriend, boyfriend, but not married in the state of Florida. Okay. So then here's the deal. The question then becomes, Lisa, what happens then? If we are not married by common law, which, gives us some rights and responsibilities, we should still have those same rights and responsibilities, right? Should have is very broad. The question is, do you have? And the answer is no. So when we talk about rights and responsibilities that you do not have, let's keep this in mind. That means that even if, let's say you've been, with this person for 15 years and you have a house together, depending on how you all are listed on the deed, if you are not listed with rights of survivorship and that person dies, the house doesn't automatically come to you. The house goes to that person's estate. And if that person didn't have a will, then that person's relatives are now entitled to portions of that estate after probate is opened up, of course. That's a whole, as my mother used to say, that's a whole horse of another color right now. We can't deal with that. But long story short, you don't automatically get it unless it's in your deed. If you all have, let's say you have children together. You both are still the children, the parents of the children, for so long as you're both on the birth certificate and so forth, and you both have parental rights and all. But the children, it's not as if the children were born in a marriage. I know oftentimes that doesn't matter right now in this day and age, but every once in a while that comes up, and that means something of great significance to other people. Even as far as healthcare and making decisions and so forth, if that other person is not able to, you two are not legally married. So unless that person has you as their healthcare surrogate or some other legal release for you to make decisions about their healthcare or their living will or so forth, then you are not considered their next of kin. You are not authorized to make any decisions about them. You are not authorized to make any major medical decisions, and you're not authorized to get any of their medical information. And so there's that. Those are some of the benefits of actually walking across the aisle. Now, I'm not telling you all that you have to rush out and go get married and, or jump the broom or, share the sand or whatever you want to call it. I'm not saying that. What I'm saying, though, is that whereas it used to be a time where if you lived as married couples, then you were considered a married couple. And now you're just in a long-term relationship, okay? I want you to know the benefits, but also the detriments to doing that, all right? Now, you might have some more questions, and that's normal. I hope you have more questions. So if you do have more questions and you'd like to get a little bit more information about whether or not, you all should say I do, or how to protect yourself in case you do need to make such decisions for your significant other, then please feel free to give us a call, 813-447-3001, LM Knox Law and Mediation. You can always go ahead and find us at www.lmknoxlaw.com. We'll be waiting to talk to you soon, okay? Take care.